Welcome to the first episode of Blanco Chats. In this series, we will be addressing questions from our brides and talking with industry experts to help guide you on the most beautiful journey of your life. Today, we are here with Carl. Carl, why don't you tell us a little bit about yourself?
Thank you so much for having me. So I am Carl Ball. I'm an admitted High Court attorney and one of the directors of Klassen Ball Associates. I've been practicing as an attorney for the past 8 years, going into my 9th year of practice, specializing in litigation, family and commercial matters.
So we've got a few questions for you today and we would love to hear what you have to think.
Wonderful.
So what are the different types of marriages in South Africa?
So in South Africa we have two different types, customary marriages and civil marriages. And under civil marriages you have three subsections, which are in community or property marriages, out of community or property marriages with the accrual, and out of community or property marriages without the accrual, otherwise known as out and out. So in the civil marriage section, in community or property, you can look at it as one pot. So your assets, your liabilities, your spouse's assets and liabilities all fall into one pot. And then we move on to out of community or property with the accrual. In that situation, you enter into an anti-nuptial contract, and it works on if you ever get divorced, the accrual will apply, which is a mathematical calculation, which we'll explain later on. And then the last one is out of community or property without the accrual, which is essentially a complete separation between the two spouses where they each retain their own estates.
Today we are going to touch on anti-nuptial contracts. Carl, please give us a brief overview of what an anti-nuptial contract is.
So essentially an anti-nuptial contract regulates the proprietary consequences or the proprietary interest in the divorce. So it regulates how things are divided, who's entitled to what assets are excluded, whether inheritances, donations, etc. are excluded in the event that you get divorced. So it's a vital contract that you have to enter into, and you have to make sure you know exactly what is in that contract.
Let's discuss that a bit further. What can and can't be included in an anti-nuptial contract?
So the one guiding principle is you can't include any provision that's against public policy, which is quite wide, but let's narrow that down to it can't be anything illegal, and it can't be anything unconstitutional, and it can't be grossly unfair to one or the other spouse. So the issue with grossly unfair is it may look unfair in a general sense, but actually it's not. So when, for instance, I use the example of just because someone excludes assets doesn't automatically make it unfair. But if they put some outrageous requirement or condition on the exclusion or inclusion of an asset, that may be against public policy and grossly unfair to one spouse. When it comes to including assets, so one of the guiding things that spouses must remember is when we talk about anti-nuptial contracts with the accrual, you have there are different ways that you can enter into this contract, and to simplify it, you can go in where both parties come and they say that their starting value is they're both zero, they're a young couple, they don't have a lot of assets and they're starting out in their career, and they both say that their starting value is going to be zero. And they may have one or two assets which they specifically exclude, and then they may also exclude inheritances, donations, gifts, etc. So that's the one way generally where couples are starting out. In other cases, you have spouses that have either been previously married or have built up a career or built up assets before they get married, and they then want to exclude specific assets, which they're entitled to do. Now there's two ways to do that. They can either set their starting value at a specific amount, so they can lump all their assets together and say it's worth X amount, and they can put that as their starting value. Or they can say that their starting value is zero, but they're excluding the specific assets from the accrual calculation if they ever get divorced. Now, another factor to consider is if they exclude specific assets, the proceeds from those assets will also be excluded. So for instance, if they have a car and they sell their car, the proceeds from the sale of that car will then be excluded, and they can purchase a new car, and the portion of those proceeds will still be excluded. You then have the anti-nuptial contract, so that's a situation where the parties are going to be married in community of property with the accrual. Now, just the last thing, the accrual is a very specific mathematical calculation. It doesn't work the same as where people understand it as, oh no, but I'm entitled to 50% of the house. What happens is, it's a mathematical calculation, the starting value to the end value. You work that out, and then the party whose estate has grown more, the party whose estate has grown less, will be entitled to half the difference between those two amounts. And that just comes down to a specific number, not a specific asset. So if you ever get divorced, the calculation is an amount. How that amount is paid, whether it's in assets or whether it's in cash, will be determined at that time. And the accrual is calculated as at date of divorce. Now we move on to the second one, which are marriages which are out of communal property without the accrual. And that is, you still enter into an anti-nuptial contract, but there is a complete separation between the two spouses. So for purposes of estate and sharing, they will have two completely separate estates, and the only consequence really of a divorce could be maintenance. That's it. Their estates, there's no sharing of assets, there's no sharing of profits. They right down the middle.
Okay, that's very interesting. So can we modify or revoke the anti-nuptial contract later if our circumstances change?
So that's a very interesting question. So sometimes what happens is parties make a mistake. So if you do not enter into an anti-nuptial contract before your marriage, you are automatically married in community of property. Now, if you enter into an anti-nuptial contract or wish to change your matrimonial property regime or change your anti-nuptial contract, you cannot do that between, it's called inter partes, so between the spouses. You would have to apply to the High Court for the High Court to grant you an order to either change your matrimonial property regime or enter into a post-nuptial contract. But in order to do that, there are requirements that you would have to fulfill. You can't prejudice another spouse, you need to give notice to your creditors, and there needs to be sound reasons for the request to change. And in doing so, it's a very costly exercise. So when you're thinking of getting married, you have to make sure that you're making the right choice, because it is a costly and lengthy process to, after you get married, changing your matrimonial property regime or your contract.
Okay, that's an interesting thing to take note of. Are there any potential challenges or pitfalls to be aware of when creating an anti-nuptial contract?
So one of the biggest problems that I find is before couples get married, they don't discuss how they are going to get married and the consequences of that, which sometimes causes issues when faced with, here's a document, you need to read it and consider it in front of an attorney. And I find that sometimes causes a lot of challenges, because one spouse in their head have made up their mind that this is how they want to get married. These are the assets that they're going to exclude, or they don't want any assets excluded. And when it comes time to drafting the anti-nuptial contract or agreeing to it or signing it, that the parties then conflict arises between the parties over an agreement. So one of the things that I suggest is, once the parties are aware that they are going to get married and intend to get married, and it comes closer to the date and time, that they have this discussion of how they would like their contract to look, what they would like to exclude, etc., and have that financial discussion going forward. Because in certain consequences, the parties, depending on how they're married, might have devastating consequences later on if they ever do get divorced. And it is a discussion that needs to be had right up front, which is horrible because you're planning your divorce, but it's actually not that. You hope it never happens, but you have to plan in the event that it does.
Okay, yeah, that's very interesting. I think another question we all want to know is, do both spouses need to have their own lawyer to draft and review the anti-nuptial agreement?
It is not an express requirement that parties do have their own attorneys to review it and to check it and sign it, but it is always advisable that the spouse who didn't instruct the attorney to draft it, that they may have an attorney look over it to make sure that it is in their best interest, that there's no errors, and that it is, in line with what they want.
Okay. And what should we do if we decide not to create an anti-nuptial contract, but still want to protect our assets or clarify financial matters?
So that's a difficult question, because if you don't want to enter into an ANC, you then get married in community of property, which is a huge problem because everything goes into, as I said earlier, one big pot. And that's assets, liabilities. If one party is insolvent, it could affect the other party. One of the ways to protect assets, which is not foolproof, is to use a system of trusts, family trusts, personal trusts, etc., to try and protect assets. But essentially your choices are that you would either be in community of property or out of community of property. And to protect assets completely, which is a decision that the parties need to make whether that's fair, is to go out of community of property without the accrual, or to go out of community of property with the accrual but exclude all the assets in terms of your ANC.
So the last question we have for you today is, when do we have to sign our anti-nuptial contracts and how would we do it?
So that's super important. As I said earlier, if you do not enter into your anti-nuptial contract before your marriage, you are automatically married in community of property, and then you will have to do the application to the High Court for basically leave or approval to enter into a post-nuptial agreement to change that. So before your marriage, you need to sit with your attorney, you need to prepare your anti-nuptial contract, and then you need to go and sit before a notary public to sign it. And that needs to occur before your marriage date. Once the anti-nuptial contract is signed by the notary public, it then goes and gets registered at the deeds office, but the registration at the deeds office does not need to occur before your marriage date. But you do not want to leave this to the last minute, so you need to plan ahead. Make your appointment with your attorney, make the appointment with the notary, and then go and sign it before the notary. The notary will then take to be registered at the deeds office, which could take a month or 2 months, maybe sooner. But once you've signed it before the notary, you can get married without worrying about whether it's valid or invalid, because it will be valid on the date of that signature. It comes into effect on the date of the marriage. And once it has been stamped and returned back from the deeds office, you will receive a copy of it. Once you receive your copy, you have to keep it in a safe place.
Perfect, thank you. Thank you, Carl, for sharing your valuable insights. We appreciate you joining us today. Brides, we'll see you soon. Stay tuned for the next episode of Blanco Chats.